Welcome everyone to this last session of the course Legal Implications of Climate Change. Today I'm looking at global climate litigation. This is actually part 2 of this particular session. Part 1 was live and was recorded and uploaded as usual. Unfortunately, I lost power at my end by the time I started and was into part 2. So what I'm doing now is recording the whole of part 2 from the beginning. So as was mentioned before, we're looking at this lecture in 2 parts. So part A consists of an investment case at the International Center for Settlement of Investment Disputes, the Eco-Aura Minerals Corporation versus the Republic of Colombia. And the second case is a human rights case, and that's what this recording is going to deal with. So, this is a case that came up to the United Nations Human Rights Committee. Those of you who studied international human rights law know that this is a complaint mechanism that is attached to the International Covenant on Civil and Political Rights. So this was a communication that came from a national of Kiribati in the Pacific and Oceania region. And the source for this case, the source documents, can be found in the complaint link as found here in that green letters. So, what was this case about? The communication was from a citizen of Kiribati who filed a communication with the UN Human Rights Committee claiming that New Zealand had violated his right to life by denying him asylum despite his assertions that climate change made Kiribati uninhabitable. The committee concluded that the communication was admissible, but that New Zealand's decision was not clearly arbitrary or a manifest error or a denial of justice. So therefore, they decided in favor of New Zealand, or rather, they did not find in favor of the citizen of Kiribati. So let's look at the details of the grievance of this national. It's worth looking at what happened before the issue came up at the United Nations Human Rights Committee. So in 2013-14, a series of court actions took place. Ione Teitiota, a Kiribati citizen, sought asylum in New Zealand, asserting that the effects of climate change and sea level rise forced him to migrate from Kiribati to New Zealand. The application itself was denied, so he went up to the Immigration and Protection Tribunal, which also denied his claim. He then went on to the High Court, where the High Court found that the impacts of climate change on Kiribati did not qualify Teitiota for refugee status because he was not subjected to persecution as is required under the 1951 United Nations Convention relating to the status of refugees. He further appealed to the Court of Appeals, and the Court of Appeal noted the gravity of climate change, but stated that the 1951 Convention did not appropriately address the issue. So while the 1951 Convention was the law that would be applied, it would not be possible to recognize the effects of climate change and its impact on migration. He then appealed to the Supreme Court, and the Supreme Court affirmed the lower court's conclusions, but opened up the possibility of considering climate change migration. So they did not rule out the possibility that environmental degradation resulting from climate change or other natural disasters could create a pathway into the Refugee Convention. So this is a matter of interest to note in the developing climate change litigation and associated jurisprudence. So that stopped there at the Supreme Court. And now, Tieteota filed a communication with the Human Rights Committee, where he alleged that New Zealand had violated his right to life under the International Covenant on Social and Political Rights. And his argument was that sea level rise in Kiribati, caused by climate change, has created a scarcity of habitable space, resulting in violent land disputes and environmental degradation, including saltwater contamination of the freshwater supplies available for the people in Kiribati. So his right to life was being affected, firstly by the violence, where he had a fear of death due to the violent land disputes that has erupted, which can be linked to the shrinking land resource caused by the rising sea level. And secondly, the lack of water that is drinkable. And that also is linked to an effect of climate change, because the salt water coming in from the sea is contaminating the freshwater supply in Kiribati. And Kiribati is recognized to be affected by climate change. As we are aware from previous lectures, the Association of Small Island States are fighting for their survival, and they have been a constant presence as well as a strong arguer for the rights of the people who are directly most affected by climate change. So looking at what happened at the UN Human Rights Committee, the committee found that Tieteota's claims were admissible because Tieteota had sufficiently substantiated his claim that when he was removed to Kiribati, he faced an imminent risk of being arbitrarily deprived of his life due to the effects of sea level rise. So why did the Human Rights Committee then state that there was no action that New Zealand took to violate his right to life? If it had to reverse the state party's determination, then there required to be an arbitrary decision, which must be very clear, and this should amount to manifest error or a denial of justice. So this keeps the balance between the sovereign decision taken to manage their own borders and people entering in and out of their own borders, and the ability to rule that a human right has been violated. So unless there is a manifest error or a denial of justice, or that the decision has been taken arbitrarily, the UN Human Rights Committee cannot intervene. But the committee further reasoned whether there was a risk of an arbitrary deprivation of life. And they reasoned that this risk must be personal rather than rooted in the general conditions of the receiving state, except in the most extreme cases. There was dissent from this, which we will look at in a little bit. What about the recognition of the effects of climate change? The committee did recognize that environmental degradation and climate change constituted serious threats to the ability of present and future generations to enjoy the right to life. This points to a gathering jurisprudence in various human rights courts, as well as this committee, on the impact of climate change on the rights of future generations, on intergenerational equity. So they did recognize that, and that was reiterated in this decision. However, they had to uphold New Zealand's determination that Te Tiota had not provided evidence that he faced any real chance of being harmed in a land dispute, or would be unable to grow his food, or would not be able to access potable water. So drilling down into the specifics of what the threat to right to life was, they agreed that these categories could be applied, but then there was no imminent risk of to the right to life of Te Tiota. So the cited cause for the risk was that there was violent land disputes. However, Te Tiota did not show that he was involved in a land dispute and that his life was at threat because of the violence that might result from this dispute. He was also not able to show that he was not able to grow food or access potable water. And some of the dissent comes from the onus of proof that needs to come. Is it from Te Tiota, or is it actually from the state of Kiribati, to show that people in Kiribati are able to grow food and are able to access potable water. The committee did, however, find that given the risk of an entire country becoming submerged underwater is such an extreme risk, so Kiribati is at that extreme risk, the conditions of life in such a country may become incompatible with the right to life with dignity before the risk is realized. Another interesting train of thought. So the risk of climate change is established, and the risk of climate change can materialize, and that is the entire country being submerged underwater. But before this risk is realized, there is a risk to the right to living with dignity. So right to life is also including the right to dignity. However, it is not reaching the mark or the threshold that the committee wants to set, saying that a state has violated the right to life if they did not recognize the right to life with dignity. They did accept Te Tiota's claim that sea level rise is likely to render Kiribati uninhabitable. The committee explained that given the 10 to 15-year time frame, there was sufficient time for intervening acts by the government of Kiribati to protect its citizens. So the ball is back in the court of the government of Kiribati. And this can open up questions around the Paris Agreement and the obligation of those that have cumulatively emitted GHG over a period of time, and how they need to help, or how they should be helping the government of Kiribati to protect its citizens, given that they are the cause for the likely rendering of Kiribati to become uninhabitable. What was the dissent about? 2 committee members dissented on 2 different points. One of them addressed the majority's reliance on the lack of evidence that Te Tiota's family lacked potable water. explaining that potable does not necessarily equate to safe drinking water. Might have potable water, but it may not be fit for drinking, fit for consumption. So in that case, a threat to life can arise if there's not enough water to drink. The second committee member that dissented argued that the committee placed an unreasonable burden of proof on Toyota to establish the real risk of danger of arbitrary deprivation of life. So let's look at both of these two dissents in detail. The first dissent by the committee member Vasilika Sanchin. Potable versus safe drinking water. So, potable water should not be equated with safe drinking water because water can be designated as potable while containing microorganisms that can be dangerous for health, particularly for the health of children. And Toyota had 3 young children, so this would be a threat to life for the family because of a lack of safe drinking water. Now, the background to this is there is documented evidence for the contamination of water, and water is a problem in Kiribati, both from contamination as well as from drought, which then links it to the inability to grow plants in the region. So the inability for Toyota to carry on with his subsistence agriculture. The committee member went on to argue for this point of dissent. The member stated that the committee found there was no evidence that he would be unable to grow food or to access potable water. The government of Kiribati had failed to take programmatic steps to provide for the basic necessities of life in order to meet its positive obligation to fulfill the author's right to life. So what is the status of safe drinking water in Kiribati? So it was stated that the government of Kiribati had taken steps to address the effects of climate change, according to their 2007 National Adaptation Programme of Action. So under the 2007 Programme of Action, there was the aim to address the water contamination from salt water, which was a direct effect of climate change. So this was part of the National Programme of Adaptation, which is, as you know, necessitated by the Paris Agreement and the Article 7 obligations to draw up national adaptation plans and to be able to enhance the adaptive capacity of countries who are all parties to the Paris Agreement. So the committee, while recognizing the hardship that may be caused by water rationing, concludes that the author has not provided sufficient information indicating that the supply of fresh water is inaccessible, insufficient, or unsafe, so as to produce a reasonably foreseeable threat of a health risk that would impair his right to enjoy a life with dignity or cause his unnatural or premature death. So it is the chain of causation that is being demanded by the committee. And there is a break in that because Toyota has not been able to establish or provide evidence that he cannot access the water, or he cannot access it in enough quantities or enough safe water, because that is what would be able to establish the health risk, which in turn then impairs his right to enjoy a life with dignity, something that might cause his premature death. Now, the argument of the dissenter is that the onus of this is really on the government of Kiribati to establish that they were providing drinking water, and if they were not able to provide that, then the committee had to take it that Tetiota did not have access to safe drinking water. So to establish that the conditions in Kiribati were less than optimal for the realization of right to life, the dissenter quoted from the United Nations Special Rapporteur on the Human Right to Safe Drinking Water and Sanitation report. So the Special Rapporteur, Ms. Katarina de Albuquerque, after her mission to Kiribati from 25th July 2021, warned that in Kiribati, the National Development Strategy of 2003 to 2007 and then the National Development Plan from 2008 to 2011 contained policies and goals of direct relevance to water, but that both these policy priorities have not yet been implemented. So this is a cause for concern in that the problem had been identified, but the policies put in place for remedying that problem had actually not been implemented. So in these circumstances, it falls on the state party and not the author to demonstrate that the author and his family would in fact enjoy access to safe drinking water or even potable water in Kiribati to comply with its own positive duty to protect life from risks arising from known natural hazards. So this is the reasoning behind why the dissenting committee member says that the committee was at fault in saying that Tetiota had not clearly established that there was a lack of drinking water which affected his right to life. So the committee's conclusion, according to the dissenting member, that the facts before it do not permit it to conclude that the author's removal to Kiribati violated his rights under Article 6.1 of the Covenant is not correct. So that's the first dissent. Gives us some food for thought about the different factors and developments to take into consideration while assessing if the right to water, which is essential for right to life, is available and has been fulfilled. So, was there a threat to the right to life because of lack of water? Can this be established by the route that the dissenting committee member suggests, which is there is a known problem and there is the inability of the government to fulfill the plans and strategies being put in place to address this problem? Does that per se then establish that the right to life of an individual is at threat if they so claim it? Interesting line of thought, gives us food for analysis. So let's look at the next dissent. This is from the committee member Duncan Lucky Muhumuza. The committee should take, according to this dissenter, the need to employ a human-sensitive approach to human rights issues. Okay, so he's already establishing that there is an approach to human rights issues that underpins the interpretation of whether there is a threat to the right to life. And according to him, there is a need to employ a human-sensitive approach to human rights issues. So he goes on to explain how he himself is doing that. The state party places an unreasonable burden of proof on the author of this communication to establish the real risk and danger of arbitrary deprivation of life within the scope of Article 6 of the Covenant. So this member of the committee is also taking a similar view, similar view to the previous member of the committee, saying that there's an unreasonable burden being placed on the author of the communication, and that burden should be shifted to the government to establish that there is no threat to the right to life because of a lack of safe drinking water. This human-sensitive approach takes the form of considering the sanctity of life. The conditions of life laid out by the author resulting from climate change in the Republic of Kiribati are significantly grave and pose a personal and reasonably foreseeable risk of a threat to his right to life under 6.1 of the Convention. So this is what this dissenting committee member is stating from the facts. The committee needs to handle critical and significantly irreversible issues of climate change with the approach that they seek to uphold the sanctity of life. This seems to resonate a bit in the majority decision of the committee when they stated that there is a right to life with dignity. Perhaps the sanctity of life goes a step further. And the focus here again is the gravity of climate change. And given the fact that we are talking about a low-lying state, so Kiribati, with its special circumstances and its special vulnerability to climate change, might be able to be one of the few countries where the right to life would be interpreted in this manner. Might not be the same if it was the right to life being claimed by someone else other than in these very vulnerable small island nation states. The impacts of sea level in Kiribati. It definitely goes to impact the sanctity of the habitable space in Kiribati. So because of the shrinking space, the people that live on it are fighting with each other for domination over this space. There is the risk for life to be extinguished as part of a violent land dispute. So this needs to be focused more on, according to Mr. Duncan. Severe environmental degradation resulting in contamination of water supply. Again, focusing on the severity of this situation of contamination of water supply. Destruction of the food crops. He emphasizes on the author's reliance on subsistence agriculture and fishing, both of which are affected by the rising sea levels. And since his removal from New Zealand to Kiribati, the author and his family have been unable to grow crops. So you see the issue. So he sees the inability of the family to grow crops as a direct evidence of the impact of the rising sea level and the lack of food being related to a threat to a right to life. The land in Tarawa, which is the home village of the author and his family, has reportedly gotten significantly flooded, with land being submerged up to knee-deep high in tides. So beyond reports of children getting diarrhea and dying because of the poor quality of drinking water, the author and his family on return to Kiribati have had bad health issues, with one of his children suffering from a serious case of blood poisoning causing boils all over the body. So we have further evidence of the impacts, particular evidence on how the water seems to be directly affecting the health of children. There is a high threshold that the committee is now laying, is the argument of this dissenting member of the community. Even as the jurisprudence of the committee emphasizes a high threshold for providing substantial evidence to establish that a real risk of irreparable harm exists, it has been critical to consider all relevant facts and circumstances, including the general human rights situation in the author's country of origin. So the point made over here is the circumstances and facts occurring in general in Kiribati needs to be taken into account. So even if the threat to life is not imminent, which is where the bar is set for establishing the right to life or the threat to life, there's another point that needs to be noted, which adds or provides weight to showing that there is irreparable harm that can be caused to the right to life, which needs to be taken into account. As a necessary corollary to the high threshold, the committee has been careful to counterbalance a potentially unreachable standard with the need to consider all relevant facts and circumstances, which comprise, among other conditions, the grave situation in this country. Okay, so currently, the dissenter is of the opinion that the committee is placing the standards to reach to establish that there is a violation of the right to life is potentially unreachable. Okay, the grave situation in Kiribati is not being taken into account. And if it is taken into account, then this dissenting committee member believes that the threshold required to be shown for the violation of a right to life is reached in this case. The considerable difficulty in accessing fresh water because of the environmental condition should be enough to reach the threshold of risk without being a complete lack of fresh water. Okay, so the dissent is about why the evidence presented of the environmental conditions in Kiribati is not enough to reach a determination of sufficiency of risk required to hold that there is a threat to the right to life. And what he says is that that risk should not be the unreachable standard, which is a complete lack of fresh water. It has to be reached even before. The conditions that are resulting now leaves the author without a livelihood and a life of dignity. So is the standard upheld in this committee that threats to life can be a violation of rights even if they do not result in the loss of life? So this is something that the committee already accepts. Then it should be sufficient that the child of the author has already suffered significant health hazards on account of the environmental conditions in Kiribati. It is also enough that the author and his family are already facing significant difficulty in growing crops. And considering the author's situation and his family, balanced with all of the facts and circumstances of the situation in the author's country of origin, reveals a livelihood short of dignity that the Convention seeks to protect. So in summing up, the dissenting member of the committee feels that the majority decision has fallen short of recognizing these conditions that prevent a life being lived in dignity, which he claims that the Convention, the International Covenant on Civil and Political Rights, seeks to protect. What is being affected is dignity. The fact that this is a reality for many others in the country does not make it any more dignified for the persons living in such conditions. So he's questioning the committee, saying it's not for each of them in that country, it's a personal risk. So just because it is a shared risk, just because Teitiota and his fellow citizens live within the same less than dignity conditions, should not in any way be taken as a general situation in that country. It still is not the standards of dignity that are sought to be protected by the Convention. And he goes on to say, sort of name and shame New Zealand almost. He says New Zealand's action is more like forcing a drowning person back into a sinking vessel, with the justification that after all, there are other voyages on board. Even as Kiribati does what it takes to address the conditions, for us, as long as they remain dire, the life and dignity of persons remain at risk. Right, so with that, we come to a conclusion on the dissent of the second committee member. And you can reflect on what you think about these two dissents and to what extent they may have contributed to determining that conditions for fulfilling the right to life actually do still exist in some of the most vulnerable countries. And finally, to aid your reflection, I want you to read some work around the role of lawyers in climate change litigation. How should lawyers behave? What might be the role of lawyers and the legal profession? We've talked so far in climate litigation about the judiciary, about how the decisions are made taking into account climate change. So how is climate change perceived in the work of the judiciary? But the judiciary does not receive cases out of the blue. It happens because lawyers act to take the decisions to court. So there is an agency of lawyers with relation to climate change litigation as a whole that needs to be considered. And as we've seen, climate litigation is global. So reflection on the role of lawyers around the globe in different countries will be useful to consider how they may play a role. So have a read of the articles that you find in the link that I've presented in the slides, and that might give you some ideas about how you might want to play a role too. I hope you are inspired to take up research in this area like I do, or you might want to take up practice in this area and I think, what might be quite an exciting career. So with that, we finished the last session of this 8-session course on legal implications of climate change. So thank you very much. All that's left for me to say now is to wish you luck with the final assignment. I hope you enjoy the work. Just to remind you, there is a revised deadline now. It's the 5th of April, the end of the day for me here in the UK, so that's British Standard Time. We will be changing clocks soon. So if you are able to submit and drop it into the designated folder by that time, I'd very much appreciate it. And thank you very much. If you've got any feedback on the whole course, please send it my way through your usual channels. Bye for now.